Sentry.
Good morning, Lord Faulkner.
Good morning, my Lord.
It strikes us, having had a few words about this before we came on the bench, that we're unlikely to require the day and a half that's been set aside for it. The main point seems to be quite a short question of statutory interpretation.
I agree with that, my Lord.
Yeah. Before we get to that, though, there is an issue raised in the respondent's written case as to your standing to be here.
As to standing?
My Lord,
yes.
So perhaps logically, that would be a good starting point.
My Lord, first of all, if it please you, my Lord and my Lady, I appear with Mr. Tom Smith and Mr. Henry Phillips. My learned friends, Mr. Gabriel Moss, Mr. Stephen Midwinter, and Mr. William Hare, appear for the respondents. As far as the standing issue is concerned, I put my case like this. It's not about Section 273. This is only about the anti-suit injunction. I submit the position is that it is a situation where, in order to give effect to the insolvency regime, we as a potential debtor are entitled to being protected against the insolvency regime being properly applied. So our position as a matter of construction is that Section 249 of the BVI Insolvency Act only allows the BVI Court, to make avoidance orders. The policy reason for that is that the BVI legislature did not want commercial relationships and contracts to be disturbed in other countries. We, as the victim of their attempts to disturb contractual relations in other countries, are entitled to the protection either of a declaration saying what the clause means, the section means, or an anti-suit injunction to prevent them pursuing it. So, my Lord, that's how I put my case in relation to standing.
Isn't that a chimerical distinction? Because what you're trying to do is disturb the liquidator's decision to take the US proceedings, for which he has the permission of the BVI court.
Correct.
So that's basically why you're here.
Yes.
And that is it not subject to the objection that you're a mere busybody in this liquidation because your real character is as a potential defendant in foreign proceedings?
Yes, but if I am as a defendant in foreign proceedings, should not be, as a matter of principle, pursued in the foreign proceedings, I am entitled to an order restraining the court, or restraining the liquidator from pursuing me in circumstances where I should not be pursued. If you, and I don't know if you had a chance to read it, there's a case called Stichtung, I think it's Stichtung and Chris, in fact, which is where Lord Sumption and Lord Toulson say this is in relation to a creditor trying to enforce an attachment in a foreign country. An injunction is given to the liquidator in order to stop the creditor getting that attachment. Lord Sumption and Lord Toulson, in their speech, in effect say the court will be ready to grant injunctions to ensure the rules of a liquidation are properly applied. I submit that that approach, namely that the court should apply the orderly rules, must apply just as much to a liquidator wrongly seeking to enforce an order in a foreign court, which the legislation in the principal court of the insolvency says should not be applied. That applies just as much as preventing a creditor, in the Stichtung and Chris case, from pursuing an attachment or an enforcement in a wrong court. It cuts both ways. It would be wrong, as a matter of principle, to allow the liquidator to go against the scheme of the liquidation, just as it would the creditors. Now, in answer to my Lady Arden's point, the Section 273 issue is a different issue, because the Section 273 is a situation where it's a statutory right to make applications, and my Lady Lady Arden is right to say that the limits of who can apply in relation to that are in effect the insiders team. If they've got a point about the way that it's going, then they can raise that with the court. But where you are being pursued in a foreign court, wrongly, by the liquidator, you have got the entitlement, just like any other litigant, to seek an anti-suit injunction or a declaration as to what the limits of the law are. That's how I put my case on standing. My Lord, it's an appeal, as your Lordships know, from the Eastern Caribbean Court of Appeal. They refused to grant an anti-suit injunction and they refused to grant an application under Section 273. The application under Section 273 is not pursued. The three Fairfield companies with which we are concerned are BVI companies. They are the largest feeder funds. They were the largest feeder funds into Madoff. Their structure was that the investors who wanted to invest in Madoff through these funds subscribed for shares. 95% of the Fairfield investments were invested into Blimis, which was the Madoff vehicle. The investors were entitled to redeem their shares in accordance with a formula which effectively valued their shares at the net asset value of the investments divided by the number of shares. Until the balloon went up in December 2008, the valuations of the investments were based on the fraudulent valuations coming out of Blimis. After their appointment, the liquidators tried to set aside the redemptions at common law in the BVI and to get back the money that had been paid to the redeemers for redeeming their shares. They failed in those applications. The BVI courts said that the matter was determined by BVI law because it depended upon the construction of the BVI Articles of Association. My Lords, that sequence of the litigation ended on the 16th of April 2014 when the Judicial Committee of the Privy Council concluded that the redemptions could not be reopened. Since then, the liquidators have been trying to get round the failure to set aside the redemptions by asking the US courts to set aside the redemptions applying BVI law by Section 249 of the BVI Insolvency Act. Whether the liquidators should be permitted to do that depends upon the scope of the statutory power confirmed by Section 249. The issue in the case is as to the scope of the statutory power created by the BVI legislature by enacting Section 249, in particular whether that statutory power is conferred on and capable of being exercised by any court other than the BVI High Court. Our case is that the statutory power created and conferred by Section 249 is, as a matter of BVI law, only conferred on the BVI High Court and only capable of being exercised by that court and not by any other court. We also say that the correct way for the BVI court as the principal insolvency court in the Fairfield insolvencies to give effect to this position under BVI law is either to restrain the liquidators from proceeding in the US by injunction or to declare that the US courts would be acting contrary to the statutory intention of Section 249 in applying that provision. The natural forum for these statutory proceedings is the BVI, and there is no true juridical advantage in bringing them in the US.
But if your complaint is that there's no cause of action because there's no power in the US court, surely that's a matter for the US court.
I submit that where the principal insolvency court has to construe, or the right court to construe Section 249 is the BVI court. They are the principal court in the insolvency. They should say what Section 249 means. It's for them to decide whether or not the right way to deal with that is by way of declaration, and then the US court can decide whether they want to hear it, or, as I submit, that they should do it by anti-suit injunction. Either is sufficient. If you look at the way that the US court has conducted itself in relation to this. They have been scrupulous in following the steers given by the BVI courts. I identify three particular examples. First, they stayed the proceedings in the US. Immediately, Mr. Justice Bannister, in effect, said there couldn't be redemptions. Secondly, they followed the Privy Council in the decision of His Honour Judge Bernstein on the 6th of August 2018, when they concluded that US law had nothing to do with the redemptions, which is what Lord Sumption had said in the BVI case, and I'll show that to you in a moment. And then thirdly, in this very matter, and I don't know if your Lordship and your Ladyship has had a chance to see it, but in December of last year, after the decision of the Eastern Caribbean Court of Appeal, His Honour Judge Bernstein allowed the Section 249 cases to continue on the basis that the ECCA, the Eastern Caribbean Court of Appeal, said that they could continue. It might be sensible for me just to draw your Lordship's and your Ladyship's attention to that. If one goes to A4, that's in the authorities, flag 1164361. It's, hold on. I've got it at Authorities Volume 4, flag 116. Yeah. What you are looking at is a judgment given by His Honour Judge Bernstein in the US Bankruptcy Court, in which a variety of applications were made to strike out the claims in America by the defendants. What His Honour Judge Bernstein did is effectively he struck out all of the common law claims except for any claim where a colourable case could be pleaded that the redeemer knew of the blemish frauds, which was not an issue that had been resolved in the BVI cases. He was invited on a range of bases to dismiss as well the statutory claims, but he did not dismiss the statutory claims, in particular on the basis that only the BVI court had power to give relief under Section 249 because of what the Eastern Caribbean Court of Appeal had decided in this case. And could I invite your Lordships to look at page 4401, which is page 41 internally in the bundle. And it's a very short bit, paragraph numbered 1 on page 41. The defendants contend that this court cannot grant the statutory remedies available under the Insolvency Act. This argument was expressly rejected by the ECCA. And it's that decision, you'll see they're referring to paragraphs 80 to 81. And if you just go to flag bundle, not the authorities bundle, but the main bundle, bundle 1, flag 18, page 215. And if you go to para 80 to 81, which is what His Honour Judge Bernstein in the bankruptcy court in the US has decided, he is relying on what is a plain green light from the ECCA. Now, to pick up my Lady Arden's point, they have rightly followed what the BVI court has said at every stage in relation to this. If this court says that actually Section 249 can only be given effect to by the BVI High Court, then our expectation is that they will follow that as well. And indeed, the matter has been brought on, and I'm very grateful to this, before the Judicial Committee of the Privy Council, speedier than it otherwise would, so that the matter can be dealt with as quickly as possible with the... Now, just to answer the question that I think is coming, the right way for the US bankruptcy court to look at this is on a proper view as to what Section 249 means. It's a matter for this court as to whether they think the right course is to say what Section 249 means, or, and that would be done by either declaratory relief or in effect what is the substance of the judgment that this court delivers. It amounts to the same thing, or by anti-suit injunction on the basis that that the BVI court should in effect give effect to the rules of the BVI insolvency. I would submit that it would not be contrary to comity because you are, in effect, the principal court of the insolvency to give a clear indication as to what this court thinks the right course is. And that may most readily be done by an anti-suit injunction.
But known concept that Mr. Justice Bernstein would have said that if court meant court in the BVI only, that the US court had no jurisdiction. That depends on the true interpretation of Chapter 15 of the US Bankruptcy Act.
I accept that.
And so it's a question again for the US court. What do they do if they see a remedy in foreign law? Do they actually have to exercise that jurisdiction, or do they exercise the jurisdiction of the New York court, this is for the Southern District of New York, under that American statute?
I accept that analysis, and I accept the analysis that it is arguable. I don't accept that that's the right argument, but I accept it's arguable under US law that even if Section 249 envisages that only the BVI High Court can grant Section 249, that nevertheless the US court might, under its view of Chapter 15, nevertheless give more assistance than that. But I respectfully submit that the right course for the BVI courts to take is to let the BVI, as the principal court of the insolvency, decide what the position is. And if the rules of a BVI insolvency are that only the BVI High Court can give the Section 249 relief, then they should restrain the liquidator from seeking to do what is contrary to the statute. That would not prevent the BVI liquidator from seeking relief in the US, because what the liquidator could do in the US would be to bring a Title 11 or a Title 7 bankruptcy and apply the normal US rules in relation to it. What is the basis upon which the BVI legislature has said only the BVI legislature can do it? The answer is because it's a matter of BVI law and a matter of BVI discretion as to the extent to which these provisions should be applied. It is unsettling to commercial dealings that somebody can swoop in from a foreign court and say BVI law can avoid transactions that would otherwise be lawful, which is the effect of an avoidance provision. So I accept the premise that my Lady Arden has put to me, namely that even if it was only doable in accordance with the statute by the BVI High Court, nevertheless, that does not prevent the BVI Court granting an injunction saying these are the rules that should be applied.
But then that becomes not an issue of the interpretation of 249, it's one beyond that BVI legislation it ought to give the court power to stop, effectively, the US court from exercising its powers.
I don't say stop. It's a matter for this court to decide, first of all, what it means in reaching a conclusion. If it went to the US courts, the US court should have a proper view as to what Section 249 means, hence the declaration. I accept what Lady Arden is saying about the power of the US court, arguably. I'm not accepting that that is the position under US law, but it would be a matter for the US courts to decide whether they've got power beyond that. But I say you should not let the liquidator go beyond the scheme. I go further than that in this case and say even if there might be cases where it would be appropriate to let the US court decide, this case is not such a case. Could I perhaps summarise what my basic submissions are, which hopefully deals in part with what Lady Arden is putting to me? I submit that as a matter of the true construction of Section 249, the right in the office holder is to apply to the BVI High Court for avoidance relief, and avoidance relief can only be granted by the BVI High Court. It's integral to the right created that the power to grant relief, which is discretionary, is only conferred on and can only be exercised by the BVI High Court. No other court has the authority to exercise that power, and the BVI High Court cannot delegate that power to some other court, nor has it purported to do so. The Eastern Caribbean Court of Appeal was wrong in concluding the reference to the BVI High Court in Section 249 was purely procedural and that the power could be exercised by a foreign court. If this court, for the sorts of reasons that Lady Arden is putting to me, were going to let the case continue in the US, because there might be some private international law rule or Chapter 15 in the US that might allow them to continue, then in my submission, the Judicial Committee of the Privy Council should set out the true nature of the power and that it can't be separated from the corporate insolvency regime, and that as a matter of BVI law, there is no basis for allowing a foreign court to perform the role assigned to the BVI court. And what's more, the BVI court, which means this court, should make it clear to the US courts that to allow the foreign court to make the decision is to misapply the BVI insolvency regime. The United States court, if the case is allowed to proceed in the US, can then make a decision whether to allow the case to proceed on a proper understanding of BVI law. And for the reasons I have indicated already, the US courts have exhibited throughout the conduct of the claims a willingness to act in accordance with the steers and the rulings given by the BVI court, which is the principal court of the Fairfield insolvency proceedings. But it's my submission that although that's one course that the court could adopt here, the other course is not to let the case go to the US. The BVI courts have the power to grant an injunction and or to refuse to sanction a BVI office holder from seeking to export the BVI avoidance provisions. To allow that export to happen here is to introduce significant commercial uncertainty and to allow a regime which is contrary to commercial expectations to be applied. It's oppressive to alleged debtors and third parties that they may have otherwise lawful transactions set aside by the decision of a court other than the court entrusted with that power. When they invested in a BVI court, it was a BVI court's discretion in relation to avoidance that formed the background to the existence of the company, not a US court's exercise of that discretion. To allow the US court to exercise that discretion interferes with the operation of the insolvency scheme laid down by the statute in the BVI, and I submit that the BVI court has power by injunction to restrain that from happening. My lord, my lady, the Court of Appeal misconstrued Section 249, and it was on that basis that the anti-suit injunction was refused. that this court can, in the light of that error, reconsider the issue of whether to grant an anti-suit injunction in this case. And as a matter of discretion, and there would be a discretion in relation to this, they should exercise that discretion, both because it's the only way to ensure that the BVI insolvency regime is applied according to its terms, but also because the BVI is the natural forum, and because there are no countervailing considerations of justice in this case, which should allow the case to proceed in the United States. In particular, there's no evidence that allowing the case to proceed in the BVI in the US will obtain any more assets for the insolvent estate, and nor would there be more assets against which judgments in the US could be enforced. So I put my case in effect in three ways. I say, first of all, at the very least, this court should say what Section 249 means, so that the court in the USA can have a proper view when they make a decision about whether to apply it. Secondly, I say, but you shouldn't let the case go to the US, in effect for two reasons. One, because it would involve misapplying the insolvency regime, which only allows the BVI court to enforce the power. And secondly, and separately, if one looked at everything in this case, there is no justification in any event for allowing the case to go to the USA. My Lord, my Lady, can I make my submissions? And I take the point that my Lord Reid made, that this is a shorter case than a day and a half justifies. I've got 6 chapters for my submissions. First of all, a number of points on the facts. Secondly, the construction of Section 249. Thirdly, the BVI law's approach to cross-border insolvencies, which I'll deal with very shortly. Fourthly, a list of what I say are the errors in the Court of Appeal. Fifthly, very briefly, the US position, which is much more a matter for the US court than for this court. And then finally, what are the right remedies in this case? Chapter 1, the facts. The 3 Fairfield companies were put into liquidation by the order of the BVI High Court in respect of Fairfield Lambda on the 23rd of April 2009, and in respect of Fairfield Sentry and Sigma on the 21st of July 2009. Lambda and Sigma feed into Sentry. Sentry feeds into Madoff. On the 24th of September 2009, the liquidators started proceedings in the BVI against successful redeemers seeking common law recovery of the sums they had received to redeem their Fairfield shares at prices which reflected the inflated value of the shares. These proceedings, which started in the BVI on the 24th of September 2009, only contained common law claims and advanced no BVI statutory claims. In April 2010, the liquidators issued their first US proceedings in the New York State Court, not in the New York Bankruptcy Court, against redeemers, making essentially the same common law claims, but making no statutory claims. Subsequently, those initial claims that were started in the New York State Court were amended to add statutory claims after Mr. Justice Bannister in the BVI High Court gave authority on the 30th of November 2010 for BVI statutory claims to be made in the US.
When were those amendments actually made?
Those amendments they started to be made in January 2010, and they were made over a period of time.
January 2010?
Yeah.
But I thought the New York proceedings were only started in April.
Sorry, 11, I apologise, yeah.
Yes, Mr. Bannister's claim is referred to in Mr. Moulton's first witness statement at MS 396.
Yeah.
So he proceeded on the basis that the statutory claims, including those which you challenge, could be pursued in front of a US court.
He did.
And no challenge was made to his order, was it?
No challenge was made to his order, but that's a matter as between the liquidator and the court, and we're not party to that, because part of the material that would go before the court, I assume, is an assessment of the prospects of success in the US court, and that's not something that you should be showing to the defendants.
You said earlier that the court hadn't purported to delegate its powers to the US court, but the BVI court clearly, in making that order, thought that these claims could be pursued before the US court.
They gave the liquidator authority to do so, yes, but I say the defendants to the claim are entitled to say whether or not to allow that is appropriate. We are not barred from making that application, just as a defendant in proceedings brought by a liquidator is not barred from seeking a stay of proceedings in the UK courts to say they shouldn't be brought in the UK courts. But
Does the record show when your clients became aware of that order by Mr. Justice Bannister?
My Lord, no.
I mean, it must presumably have been not later than sometime early in 2011 when the applications were made.
We must have become aware of their authority to do that when amendments were being made to the claims against us in the US proceedings.
So early in 2011?
Exactly, yeah.
Because presumably the applications to amend would have cited the authority.
Yeah. My junior, Mr. Smith, is pointing out that subsequently, and you'll see this, Mr. Justice Bannister persistently tries to withdraw the permission to continue with the BVI statutory claims, but ultimately the Court of Appeal obviously allows it because of the result in this particular case. But can I come back to that? Just let me go through the story. The claims in America are against some of the same defendants as in the BVI, but are also against additional defendants. They are, in all cases, subject possibly to erroneous duplication in respect of different redemptions to those covered by the BVI proceedings, though we would submit that they all raise the same points. On the 7th of May 2010, Mr. Justice Bannister makes an order under Section 472 of the BVI Insolvency Act, authorising the liquidators to act as foreign representatives in the US. And it may be that your lordships just look at that briefly, which is in 1/4/14. You'll see there.
Page.
Sorry, it's bundle 1,
yes,
flag 4, page 14.
The MS
electronic
number?
page.
Electronic 14. Number? It is 14.
14, sorry. All the numbers I give, sorry, are referred to electronic, but I apologise.
Thank you.
Thank you.
And over the page 15. On the 22nd of July 2010, the liquidators are granted recognition as foreign representatives in accordance with Chapter 15 of Title 11 by the US Bankruptcy Court. That's not in the bundle. That's the 22nd of July 2010. The US court, the Bankruptcy Court, gives recognition under Chapter 15. On the 30th of November 2010, and I've already referred to this, the BVI court authorises the liquidators to make statutory claims in the US court, and that's page 17 in the electronic bundle, and it's flag 5 in bundle 1 hard copy. That's what we've just been discussing, but that's the order that we've been discussing. Then, on the 20th of April 2011, Mr. Justice Bannister rules in favour of the redeemers in the BVI proceedings on a series of preliminary points, and on the 10th of October 2011, he gives summary judgment dismissing the liquidator's claims in the BVI because of his ruling on the preliminary points. That's page 34 in the bundle, bundle 1, flag 8, which I don't think we need to look at the detail of. The significance of that is that brings to an end, at first instance, the attempts to get back the redemption monies. On the 19th of October 2011, His Honour Judge Lifland, who is the bankruptcy judge in the US, sitting in the US bankruptcy court, stays all of the US proceedings pending the conclusion of the appeals in the BVI and pending any appeal against a decision that's going on in the US about whether or not cases that have been started in the New York State Court should be remitted. There's some cases that have been started in the New York State Court. They're referred to the US Bankruptcy Court, and then there's an issue about whether or not they should be referred back to the New York State Court, which is a US issue. Could I invite your Lordships and your Ladyship to look at 4/40, page 582 in the electronic bundle. This is 40. This is dated the 5th of, it's dated the 19th of October 2011. And just out of interest, you'll see it's a Chapter 15 case now in the US Bankruptcy Court. And paragraph 1 is the relevant one, and it's staying everything. A, because of what's going on in the BVI court. B is a reference to the question of whether or not cases that have been transferred from the New York State Court to the US Bankruptcy Court, that issue, it disappears in the end. But it's A that I'm particularly relying on. On the 8th of November 2011, Mr. Justice Bannister refuses sanction to the liquidators to continue the US actions, both in respect of the common law actions and the statutory actions. And that's to be found in Bundle 1, Flag 9, page 38 in the electronic bundle. And that's an ex parte application. Then if you go over the page to page 40, the Court of Appeal in the BVI then overturn Mr. Justice Bannister's order withdrawing sanction for continuing the proceedings in the US. The Court of Appeal, again ex parte, then restore the permission pending the appeal to the Eastern Caribbean Court of Appeal. And what's happening there is Mr. Justice Bannister has made his order. The Eastern Caribbean, the appeal against his order has not been heard by the Eastern Caribbean Court of Appeal, and they allow the cases to continue in the US pending the hearing of the appeal in the ECCA. Now, the significance of that, obviously, is Mr. Justice Bannister's view was if he was right and that was upheld, then they shouldn't have permission. The Court of Appeal's view was, well, whether he's right or whether he's wrong is not yet resolved because we've got to hear the appeal. And this is not the appeal in this case, but it's the appeal that eventually ended up in the Privy Council in 2014. My Lord, the Court of Appeal upheld Mr. Justice Bannister's order, and then, as I've indicated, the Privy Council dismissed the liquidator's appeal on the 16th of April 2014, and the Privy Council's decision is to be found at 11399. And could I just, because it comes up later, while we're looking at this, refer your Lord, I'm not going to go through it, but basically what Lord Sumption and the Privy Council decide is you can't reopen these redemptions. Consideration was given for the redemptions, namely the giving up of the shares. Anyway, the documents were certificates that can't be challenged. He says something about the New York subscription agreements, which becomes significant later. If you go to page 108, which is paragraph 20, and I just invite your lordships to look at paragraph 20. And it's, in particular, it's the last few sentences of paragraph 20. The effect of the articles is therefore properly pleaded before the law, and it's got nothing to do with New York law. The US The United States stay granted by His Honour Judge Liffland continues in effect until July 2016, which is until after Mr. Justice Leon in the BVI court on the 30th of March 2016, in this case, has refused the redeemers the orders they seek in this application, preventing the liquidators continuing with the US common law and statutory claims. Despite that, Mr. Justice Bannister, on the 6th of April 2016, refuses the liquidators' sanction to continue the US proceedings. That's on the 6th of April 2016, but that is overturned by the Eastern Caribbean Court of Appeal on the 24th of June 2016. Neither of those orders are in the bundle, but I can get them for you if your lordships want them. My lords, Mr. Justice, His Honour Judge Bernstein, who is now in charge of the bankruptcy case in the US, allows the case to continue on a limited basis from 2016 till 2018, when he makes a series of rulings, which, as I've indicated by taking you to the last of those rulings, in summary, involves dismissing all of the common law claims on the basis they've been resolved by the Privy Council, except for any claims where the liquidators seek to establish that the Redeemer knew of Madoff's fraud. He refuses to dismiss the statutory claims on the basis the ECCA have said the US courts can determine them, and that's relying completely on what the ECCA have said in this case. He also rejects a variety of knockout blows which are advanced by the defendants in relation to the statutory claims, saying they should go to trial, in effect. My Lord, prior to that ruling, which I referred you to, which is at A41164361, he had given a ruling on jurisdiction in relation to personal jurisdiction, and he had addressed the question of whether or not the subscription agreements, which were governed by New York law, meant there was in effect a submission to the jurisdiction of the New York court. Now, your lordships, I understand, have that separately. It was agreed between the parties this could be put to you. Does your lordship have... it might be... It's a decision of His Honour Judge Bernstein on the 6th of August 2018.
That decision on jurisdiction?
Yes, it is. I haven't got a page number for it in the electronic bundle.
Yes.
No, it's
No.
not in the main bundle. It's separately,
Okay.
it's separately included.
So I apologise for that.
We weren't told about these, but we objected to them as being...
No, you didn't object to this one. You agreed to this one. What you objected to was the authorities I referred to on Friday. So they've agreed to this one, but they've objected to authorities that I put in late on Friday. I'm sure entirely legitimately, but this one they can't object to. Can I take you to that decision of His Honour Judge Bernstein, in which he's addressing the question, does the New York court have personal jurisdiction over all of the defendants? And part of the justification relied on is a submission to the jurisdiction in the subscription agreements. And if I take you to, I'm not quite sure what your numbering is in relation to it.
We have internal page numbers.
Which are the same as the
Okay,
printed
that's
pages.
fine. If you go to page 19, and if you look at page 19, that's the clause in the subscription agreements that are signed by investors in Fairfield, which is being relied on to say there's a submission to the New York jurisdiction. And if you then go to page 25 and read from the heading, furthermore, the Privy Council in Migani and read to the paragraph just before, I must stop here.
Yes.
I refer to that to indicate that there's no submission to the jurisdiction in advance benefit to the proceedings being in the US. It's also clear that the proceedings are not being brought in the US because it said that there are any significant assets in the US. This is not a case where it is being said that assets are being squirreled away. And in that respect, could I just take you to bundle 4, page 30, flag 39, and it's page 529 is where the decision starts. It's an appeal from His Honour Judge Liffland to Her Honour Judge Preska about the question of whether or not certain cases should be remanded from the US Bankruptcy Court in the Fairfield litigation back to the New York State Court. I don't think your lordships need to trouble with what the basis of the appeal was, but if you go to 545, and this is a Fairfield case, if you just go to the middle of page 545, and just, if we read, did you see the sentence starts, the foreign representatives seek recovery of foreign assets by challenging foreign transfers. In these cases, there are no assets sought within the territorial jurisdiction of the United States. Nowhere in the complaints, plaintiff's papers, defendant's papers, or at oral argument can there be found a non-frivolous reference to any assets sought that are located within the territorial jurisdiction of the United States or in possession of a US domiciled defendant. And then if you go on at oral argument, the assumption of all the parties was that no tangible assets were located in the United States, and at no time did any party proffer a suggestion of assets sought within the United States. And then I'd invite you just to read the footnote 3 as well.
And when the judge talked about these cases...
These the same cases.
It's the same case.
Yeah, exactly. And then that is echoed in the evidence in this case, what is the reason for the proceedings being brought in the United States? Could I go, first of all, to Bundle 3, Flag 30, page 393, which is the evidence of Mr. David J. Moulton, who is a lawyer instructed in the States on behalf of the liquidators. And if I just ask you to read on page 394, para 4, and I just ask you to read the first two sentences. I understand that a separate witness statement has been prepared by the liquidator, setting out the reasons for bringing the New York actions. I do not comment on that. And then could I ask you to read paragraph 7 as well, on page 395. I draw your attention to the subscription agreements, and I've referred to the relevant material there. That's all there is in Mr. Moulton's affidavit. That's obviously intended to kick it over to Mr. Chris's witness statement, which is to be found at flag 31. Could I invite your lordships and your ladyship to read, go to the 30-second witness statement of Kenneth Chris starts at page 418 in the bundle, and the relevant factual material is paragraph 11 through to paragraph 16. The key paragraph is paragraph 14, and what they are saying, in effect, is we're bringing the proceedings in the US wherever we can establish jurisdiction in the US. It's not being suggested that there are assets in the jurisdiction, and it can't be suggested that if they bring these proceedings in the US, they would be more readily enforceable against the defendants because there is no prior submission to the jurisdiction in the light of His Honour Judge Bernstein's finding.
When in paragraph 11 it said that that many defendants in designated New York bank accounts for receipt of redemptions and or received the redemption payments through US bank accounts, is that really just a matter of history?
I don't dispute, I'm not in a position to dispute that as a matter of evidence, but it doesn't mean that means that they're present for the purposes of the enforcement of judges. It might well make them present for the purposes of the long-arm jurisdiction of the US courts. I say this because the case would be a different case if what was happening was people were trying to bring proceedings in order to get at assets that have been hidden in a particular jurisdiction. But that is not this case. This is a case where it's just convenient for us to bring the proceedings in the US. It is not, we need to invoke the jurisdiction of a foreign court in order to get at assets that somebody's hiding from us. And you can see that in relation to the particular defendants before you, which are the UBS and now Mitsubishi defendants. If you go to flag 29, it's in bundle 3, flag 29. If you go to paragraph 7 through to 15.
Page reference, please.
Sorry?
Page reference?
382, sorry. And if you go down from 7 to 15, the first company of the appellants is a New York company organised under the laws of New York and has its place of business in New York, and it redeemed some shares in Sentry. But basically, most of the UBS companies, and this is the position right across the board with the defendants, they're from many, many countries, mostly they have submitted to the jurisdiction both in the BVI and in New York. The point I make is there is no advantage, whether it be in the BVI or New York, as to whether or not there is a submission to the jurisdiction. My Lord, finally, on the facts, I would invite you just to look at the complaint in the States, which is Bundle 4, Flag 51, page 813. This is just an example of the complaints being made in the USA. You'll see, just out of interest, you'll see it's headed Chapter 15 case below the words United States Bankruptcy Court, Southern District of New York. If one goes to, I don't want to go through the common law claims because they've all been struck out or are not relevant to you. If you go to 845, does your Lordship and your Ladyship see the 8th claim?
Yes.
From the 8th claim through to the end of the body of it at 851, it's basically the statutory claims, which are basically relying on all of the same facts that make up the common law claims. And then it's the 8th to the 11th claims are the statutory claims. Could I invite your Lordships to look at 851, heading Prayer for Relief, and then over the page 852, if you look at the relief that is sought under D and E, a declaration is being sought, first of all in relation to the unfair preference and then in relation to the undervalue claims, but then the relief which we say can only be granted by the BVI High Court. So they're asking for the order that we say can only be made by the BVI High Court. Chapter 2 of my submissions, which are the construction of Section 249 of the BVI Insolvency Act. My Lord, I don't know if it's convenient to have open the BVI legislation. It's to be found in Bundle 5 of the Authorities Volume, Flag 128, and it's to be found at page 4737 in the Authorities Bundle. And subject to Section 250, I'm sure your Lordships have read it. It's discretionary. It sets out a variety of things that can be done. It only comes into force when, for the purposes of this particular case, either Section 245, the definition in Section 245, which is unfair preferences, has been satisfied, or Section 246, an undervalue transaction, has been satisfied. Both Section 245 and 246 give rise to no right to relief at all. They are simply definitional sections. Section 249 is the section that allows for the granting of relief. It is not the same as, but has plainly its model is the Section 238 and 239 of the Insolvency Act in the England and Wales 1986. My Lord, I make the following submissions in relation to it. As a matter of construction, it is plain that what is envisaged is that a discretion is given to a particular court. The right is not a freestanding right. It is a right in the liquidator to apply to the court and get relief from that court. The right does not stand apart from the application to the court. The right is discretionary and gives the liquidator no rights without an order of the court. The purpose of these rights is not to give an individual creditor a right, but is part of the collective process which the insolvency arrangement involves. Finally, it involves the setting aside of transactions which would otherwise be lawful and therefore depends upon court intervention. Where there is a collective process such as this, such as an insolvent liquidation, that process requires one umpire, and that umpire necessarily has to be the principal insolvency court, and that is the BVI High Court. My Lord, I submit that avoidance provisions differ around the world. The decisions made by the legislature in an individual country as to what the terms of avoidance are involve both what are the terms, but also frequently a discretion in the court. And it is the court they identify that has that discretion. Could I ask you in that respect to look at what Lord Collins said, and you may well be well acquainted with it, in the Rubin case, which is a very significant case in this area, which is A31124225. It's flag 112. The question that the Supreme Court were dealing with in Rubin was, does insolvency constitute a special regime for the enforcement of foreign judgments, or do the normal private international law rules apply? You've got to be present in the court that's rendered an insolvency judgment against you. And Lord Collins, contrary to what Lord Hoffman had said in the Cambridge case, says actually the ordinary rules of private international law apply. There isn't a special regime for insolvency. Modified universalism does not go as far as to say a foreign judgment rendered without the defendant being, inverted commas, present in private international law sense. They can't be enforced in England. But he says he is, if you go first of all to paragraph 15 of his judgment, and he specifically identifies the fact that insolvency law reflects public policy, and one particular area where public policy is particularly involved is avoidance provisions. And then could I also invite your lordships to go to, could I also invite your lordships to go to page 4241 in the same judgment, paragraph 94 to 98, under the heading Nature of Avoidance Proceedings. At its heart, my case is, when you invest in a BVI company, you sign up to the BVI law on avoidance, which involves the BVI High Court exercising its discretion. You didn't sign up to the US court doing it, there may be cases where, in order to ensure that people should not use borders as a means of hiding their assets from the creditors, that you need to invoke relief abroad. But this is not such a case, because all that is really being said when you look at the facts is it looks more convenient for us to deal with the cases in America. Well, there's nothing to justify that in this case, and there's nothing to justify breaking the terms of the Insolvency Act. The thought that is going through people's minds may be, well, if the liquidator thinks there's a benefit to it, I'm sure this is not the thought, I mean, the thought that was going through my mind was, it may be that if the liquidator thinks that there's some benefit in it, it's not for this court to second guess, or any court, to second guess the judgment of the liquidator, as long as it's a sensible judgment. But that is not, in my submission, the right way to look at it. If there is a scheme of insolvency, then that scheme should be applied unless there is a good reason for not applying it. There isn't any reason, let alone a good reason, for not applying it here. In any event, I say, if the American court is going to consider whether or not they're going to go outside the four corners of the scheme, then they should know what that scheme properly means.
The thought that was going through my mind...
I wasn't suggesting that thought was going through.
was something different, but I'll share it with you.
Oh, I'm very much obliged, my lord.
But it's simply an off-the-cuff thought. A provision in the form of Section 243 or Section 238 of the UK Act, both allows for the avoidance of the transaction in question, and also gives the court a power to make such order as it thinks appropriate following the avoidance.
Yeah.
Now, that type of provision is relatively recent, and in older statutes you found provisions which simply provided for the avoidance of the transaction. And it was then left to the general law as to what the liquidator then had to do, what law governed what then followed. And if it were property, for example, the liquidator could simply exercise the statutory power to ingather the property of the company. If it were money, he, under English law, would have a remedy for money hadn't received. And there might or might not be defences to such a claim. Now, we had a case not very long ago from the Bahamas where the question arose, what system of law governs the recovery following avoidance where there's a conflict of laws situation? And the view being urged on us was that if under one of the old style provisions you had to rely on what's effectively a claim, a species of unjust enrichment, essentially, the system of law which would govern the claim would be that of the jurisdiction where the enrichment occurred. So if you have one of the old style provisions, and if that view is correct, then under an old style provision, if the enrichment occurred, for example, in New York, then the law of New York would be the one that governed the claim. And so although you had a BVI, or just say it was Bahamas insolvency, because the Bahamas has got an old style unfair preference provision in its insolvency law. So you'd have a liquidator appointed in the Bahamas. The avoidance, the court would avoid a court would avoid the transaction, and the liquidator's right to recover the money would then be governed by the law of New York. Now
wouldn't there be a judgment then in the court avoiding the transaction So assume
Yes.
that the court avoiding the judgment says, I hereby order that A pays the money to the liquidator. The question would then be, could you enforce the judgment avoiding the transaction in the foreign court? Because there wouldn't be a separate question, would there, about recovery of the amount ordered by the... It would be a question about enforcement of a foreign judgment.
Well, that's the point, that there would be a separate question about recovery.
Well, recovery... I'm being incredibly dense here.
Well, you see,
Are you assuming... Sorry.
See, you see, if you ask, once... whenever, even outside insolvency law, if you avoid a transaction...
Yeah.
The right to recover money paid under the transaction doesn't necessarily follow as night follows day.
No, I agree.
And so there has to be some legal basis for the recovery of the money, which would normally be that in this case, the entire transaction had fallen, the money was paid under a mistake, effectively, and so it's repayable.
I mean, is the question for me, what system of law do I say governs the recovery of any sum payable as a result of an order being made under Section 249 of the BVI High Court?
Well, it wasn't so much that as that what was going through my mind was that if under one of the old-style provisions, New York law could govern the recovery of a payment, does the fact that under a new-style provision you wrap together in one section both the avoidance and the remedial power mean that it becomes a matter for the law of the governed entirely by the jurisdiction of the insolvency?
I submit that the right way for the court to approach that is where you are dealing with what you've described, and I don't dissent from, these new-style avoidance provisions, which are sort of post-Cork type avoidance provisions, that the question should not be viewed as a question of, as it were, standard private international law, but a question of what are the circumstances in which assistance should be given by one country to another, because these are not unlike, as it were, Section 172 of the Law of Property Act, which is the old-style provision, and there is still an old-style provision under Section 81 of the Law of Property Act and the BVI. These are all new-style provisions which are not intended to give individual rights like the LPA 172 does. They're collective rights given to the liquidator. And obviously, on the face of them, they are governed by BVI law. The question of what is the consequence in relation to... are you thinking of a case where, for example, the BVI has said, I want to avoid this transaction and the money is in New York, how do you get it back? Then the answer almost certainly is what relief, what assistance will the US bankruptcy court give you to get that back? And separately from that, the question will be, to what extent will the US courts be willing to enforce the judgment in the BVI? I think it depends on that. I don't think it depends on private international, but I mean, I could be wrong.
Well, Paul, on a slightly cruder thought that's going through my mind,
Yeah.
you might want to deal with, is really this. You said, well, when you invest in a BVI company, you sign up to the BVI jurisdiction on avoidance rather than that of the US court. I can well understand why you sign up to BVI law as to what is or isn't a transaction undervalue or a wrongful preference. But I'm in some difficulty wondering why an investor would think, if he's, let's suppose, ordinary resident in New York, and let's suppose that's where he has his assets, that's a second set of questions, why he should think that he's also signing up to only having a BVI judge exercise the discretion rather than a New York judge, bearing in mind that if one looks at 249, and of course it's discretionary, the court may make an order setting aside the transaction, or it may, in relation, we're here concerned with preference, make a status quo ante order. One's not expecting the court just to say, well, I don't know, I'm not going to make any order, it's a nice sunny day in the BVI. What the court is doing, surely, is deciding how best to give effect to its conclusion that there has been a preference.
Yeah. And
Well, why should a New York judge be any less well placed to do that in relation to a New York entity that's been preferred than a BVI judge?
well, 2 or 3 reasons. First of all, in making the decision as to whether to make an order, the thing that one has got to look at is, first of all, the overall picture in relation to the insolvency. Well, suppose the position is that this is an otherwise lawful transaction and you don't need to set these transactions aside to ensure that almost or all of the creditors will be paid, or you only need to set them aside in part to ensure that there is not an insolvent liquidation. Why should the New York judge, who is simply ancillary to what is going on, be in a position to make a judgment in relation to that? Secondly, and separately, one of the features that the judge will be able to look at is the extent to which it's appropriate for an order being made in the BVI jurisdiction should intrude upon settled agreements in the US. And then thirdly, it is reasonable to assume that a BVI court judge, aware of what the practice is in the BVI, may well come to a different conclusion in relation to the exercise of discretion than a US judge may do. I did not sign up to, says the investor, I mean, or slightly unreal this, but I did not sign up to a US judge in bankruptcy doing it. I did sign up to a BVI judge doing it. So those are the 3 reasons.
Yes, but surely the US court is trying to assist the BVI insolvency, and it will have submissions from the liquidator on each of the points that you've mentioned.
Yes.
Including practice, the state in the liquidation, so some partial order possible. One would expect it to be the duty of the liquidator to point out if the liquidation is going to be solvent, and that only a partial setting aside was appropriate. That would all be before the US court, and the US endeavour is to assist in the BVI liquidation, so it'll be putting itself into the shoes, with the benefit of assistance from the liquidator, the shoes of the BVI judge.
Yes, and it can provide that assistance, and indeed this is what the UNCITRAL model law envisages. It can provide that assistance by, for example, applying US avoidance law, where it can then make its own judgments about the law. Your question to me poses the question, is what the US judge exercising Section 249 jurisdiction intending to do, is it he is trying to judge what the BVI court would do, in which case you've delegated the discretion to him, or is it exercising the discretion on the basis of what it would regard as the meritful factors? And if you've placed the power only in the hands of one particular court, namely the BVI High Court, then it should only be them who do it. You can provide the assistance that your ladyship has in mind, can, for example, to get assets that have been put beyond the reach of the BVI court, can very readily be provided under Chapter 15. But Chapter 15 normally envisages the US avoidance law being provided, though I accept there are cases that say maybe they can go wider.
But is there any evidence here about Chapter 15 and to that effect?
Well, there is there's the in terms of there's the UNCITRAL working papers, and can I come to those in a moment? But basically, can I say what I say they show? I say that what the UNCITRAL working papers show is that there was real antipathy to the idea of an assisting court applying the principal court's avoidance laws. The basic reason for that was that where you are applying an avoidance law, you are in effect setting aside transactions and commercial dealings that would otherwise be legal. it unsettles commercial dealings that a foreign avoidance law can come in to a foreign country, in effect, and set aside what is otherwise an established commercial dealing. The decision of Mr. Justice, His Honour Judge Glenn, in the Hellas 2, which we'll look at in a moment, but this is not about American law. This case is about BVI law. Says, well, maybe even despite that, we can do it. Mr. Justice Morgan, which is a case in the bundle called Fibrosa and Pan Ocean, in effect sets out what the anxieties are about allowing avoidance law from one country to be applied by another, because it has this effect of unsettling settled deals. There is one big example where it's allowed, and that is in relation to the EU insolvency regulations. I would refer you to the EU insolvency regulations, but Mr. Gabriel Moss will object because I only mentioned I might refer to them on Friday. If privately you wish to look at them, you will see that in Article 7.2m, a EU country can apply the avoidance law of the principal country, even though it's different from where the application is being made. But there are specific protections built in as to the restriction on the application of the ability to apply the avoidance law. What I say the right approach of this court is, if you are going to allow one country to apply another's avoidance law, it should be done pursuant to international agreement, as was done in the EU insolvency cases. And again, I should make it clear that Mr. Gabriel Moss objects to this, but there are the working papers that preceded the European Union insolvency regulations, which made it clear there were these problems, but this is the way that you deal with them, in effect building into the international agreement the protections to try to preserve and protect settled arrangements. Now, what you've got here is the model law, which is Chapter 15, because Chapter 15, and you can, I mean, this is maybe straying into American law, but you can see it. It says specifically in Chapter 15 that it's the application of the model law. It's only intended to be a modest series of procedural changes. It's not intended to be this big change that the EU insolvency regulations brought into effect. So I am making a very simple point in the right way for the court to approach this. You've got to construe the statute in section 249. If you come to the conclusion that it only can be applied by the BVI High Court, then the right course is the American court shouldn't apply it. Doesn't mean they can't give assistance, but the way they give assistance is by applying their own avoidance law with all the protections or unprotections that may give. And that's the standard way of dealing with these cases. And you're... sorry.
No, finish.
I was
about
about
a
to
question
say,
at the end.
This is not the right language, but you're going too far in interfering with cross-border insolvency if you either you let the liquidator do it, because you're then changing the basis of the insolvency regulation. Alternatively, if you think it should be for the American court to decide, then by all means let the American court decide. And they've always been keener than either the English court or common law courts to provide assistance. If you're minded to let them decide, well, do tell them what you think Section 249 means, that it was intended only to apply. Give the power to the BVI High Court, and it's part of a structure where the exercise of the jurisdiction by the BVI High Court was an integral part of it, and then let them decide.
What was the date when this modern form of provision was first enacted in the BVI?
I think it's 2003.
And can you remind me what the date of the English in cross-border insolvency regulation is?
2006.
This is the cross-border, 2006. Could I just, and this is just to partly to deal with some points made in the Eastern Caribbean Court of Appeal, and partly just to indicate what the effect of these provisions is. First of all, the BVI courts assert jurisdiction over anyone in the world to apply these statutory provisions. So it's not a case where they can only reach people within the BVI. It doesn't mean, obviously, that any judgment rendered subject to a decision made under the long-arm jurisdiction of the BVI courts would necessarily be enforced elsewhere, but they, like the English courts, would assert that power. And could I just show you where that comes from? It's A5, tab 127. These are the civil procedure rules.
Page.
4608. 4606 is the front piece. (4608) is the rule, and the relevant. Does your lordship? Sorry. Your Lordship, see, the court may permit a form to be served out of the jurisdiction if the proceedings are listed in this rule. And then if you go to 10 on 4610, there's a statutory power. Claim is made on an enactment which confers jurisdiction on the court, and the proceedings are not covered by any of the other grounds referred to in this rule, and I don't think that they are. That's where the power comes to serve out. Secondly, I submit, I don't think this is really contested, that the English parallel provisions, and therefore these provisions, have extraterritorial effect, i.e. it doesn't matter where the relevant transaction took place. In support of that proposition, I rely on a case called Paramount, which is in the A3, the authorities bundle A3. Which I can't momentarily find. Here it is, A3, yes, and it's flag 108. And this is a decision of the Court of Appeal. It's page 4074. And the administrators wanted leave to serve out on a section 238 or 239 claim, and it was said that 238 and 239 applies to any person, and what was being said by the defendants who were a bank in the Channel Islands, any person can't mean any person. There must be some territorial limitation to the effect of section 238 and 239. And Sir Donald Nichols, as he then was, with whom the rest of the court agreed, said, no, that's not right. If you look at page 4090, you see the last sentence at E. Well, sorry, perhaps I should start at 4086, letter F.
Yeah.
Down to the end of that first paragraph. So he's saying, look, this appears to apply to every transaction anywhere. Then what happens in the next bit of his judgment is he deals with all the arguments as to what might be a limitation on that, and then he eventually concludes at 4090 at letter E, the expression that therefore must be left to bear its literal and natural meaning, any person. So there's no personal or territorial limitation. And then it's worth reading just F to the top of page A on 4091, where he says, but you can take into account territorial things when deciding what order to make.
Yes, well, broadly one assumes foreign convenience grounds.
Exactly. But well, he's going further than that. He's saying it's not just foreign convenience, it's also what order you make at the end of the day may be affected by the territorial connection. So if you look, the discretion is, he's talking about the discretion to make the order. The discretion is wide enough to enable the court, if justice so requires, to make no order against the other party to the transaction or the person to whom the preference was given. In particular, if a foreign element is involved, the court will need to be satisfied that in respect to the relief sought against him, the defendant is sufficiently connected with England for it to be just and proper to make the order against him despite the foreign element. Now, what that means, as I understand it, is you can't just use these provisions to go halfway around the world to try to set aside a transaction where it's got absolutely nothing to do with England, in this case the BVI, and it would be unjust looking at the circumstances of the transaction because it's so distant from England to allow it to be set aside. And that's a factor, as I understand Sir Donald Nichols's then was his judgment, to be taken into account, not in determining whether or not the English court hears it, but what order to make in applying the discretion under section 238 and 239. But we're just going on with my submissions. I submit that there are quite a lot of examples that one can find of where, in granting a right, it is inherent that only the court, given the power to grant that right, can make any order. And examples of that exist in this area of the law include, and it's quite fashionable now in the English court, sanctioning a Part 7 transfer under Section 111 of the Financial Services and Markets Act, transferring books of insurance or banking business from one entity to another, which plainly could only be made by the English court. Another example of such an order is making an order disqualifying a person from acting as a company director under the Company Directors Disqualification Act. That couldn't be made by a foreign court. Another is making an order giving effect to an English winding up. A foreign court could not wind up a company in accordance with an English statute and thereby trigger all the provisions that then apply under English law. Another example is making an order under Part 30 of the Companies Act 206, where a shareholder in a company has been the victim of unfair prejudice. Section 994(1) of that Act enables a member to apply to the court by petition for an order, and then Section 9961 confers a power on the court if the court is satisfied that a petition under this part is well-founded. It may make such an order as it thinks fit for giving relief. And then, as your Lordship knows, Section 11561A of that statute defines the court as meaning, except as otherwise provided, the High Court of England and Wales or a county court that has jurisdiction over the particular company. And those are all examples where it's obvious, looking at the meaning of the provision, that they envisage that only a particular court can make the relief. My Lords, two examples from abroad. First of all, Canada. If you look at A4125, 125, and it's page 4587 in the bundle. And it's a case about whether or not proceedings should be stayed in the Alberta courts in order that a case could be heard in Florida. And one of the arguments given is you can't let the case go to Florida because part of the relief sought depends upon Section 180 of the Alberta Companies Act, which enables the court to give release when certain regulations are broken, and they can only be given by the Alberta court. Now, the significance of the decision is, if you go to 4594, it's a puny judge, an ACJ, maybe Associate Chief Justice of the Queen's Bench Division, Mr. Justice Whitman, if you go to look at paragraph 63, that's the relevant section, he then, and I don't invite you to read it now, but I invite you to read it at your leisure, from 63 through to 82, he considers whether or not it's only the Alberta court that can give the relief. He then considers a whole series, effectively, of Canadian and American cases, primarily dealing with the internal management of companies, and says, in effect, where you're dealing with the internal management of companies incorporated under particular laws, only that jurisdiction under which the company is incorporated can make the sorts of orders that one's referring to. If you look at paragraph 76, which is a rather lumbering way to get to this point, which is on page 4595, 76. These cases demonstrate that there are two considerations that drive the conclusion that the domicile of the corporation is the proper jurisdiction to deal with matters of internal corporate governance. And we're not talking about internal corporate governance and the status of corporations in this case, but he says the language of the governing statute and considerations of comity and perhaps more generally public policy. Now, I appreciate it's not quite the same, but the question that the judge is asking in the Alberta case is it appropriate to construe this section as only applicable by the Alberta court? And he's saying, yes, it is. And I submit the sorts of considerations he's got in mind are the appropriate considerations in seeking to construe the statute. The construction, the policy, and comity. My Lord, those are my submissions in relation to the construction of the contract. My Lord, it may be worth summarising what I say in summary. In my respectful submission, the effect of Section 249 is it requires an application to be made to the BVI High Court. It creates no rights until the BVI High Court makes an order. Thirdly, there is no decision that we are aware of which involves these provisions, that's Section 249, giving rise to a freestanding right which has not involved an application and an order from, in the case of Section 249, an order being made by the BVI court, or an order being made under Section 238 or 239 of the English Insolvency Act, which is the equivalent, being made by a court other than the English court. And fourthly, neither the United Kingdom nor the BVI courts have ever decided in inter partes litigation, except in this case, that a foreign court can apply these avoidance provisions. And I submit that the English courts themselves would not apply a foreign court's avoidance provision unless there was a specific piece of legislation authorising it, which would reflect international agreement, which is my point about the EU insolvency provisions. Thank you. My Lords and my Lady, could I go on briefly to BVI law's approach to cross-border insolvency? My Lords, the law on cross-border insolvency, as far as English and BVI law is concerned, is mainly concerned with incoming, by which I mean applications being made in the English court or in the BVI courts seeking assistance for a foreign court. And whatever the BVI court or the English courts are prepared to do is not necessarily an indication of what the right course in relation to this case is, because this is an outgoing piece of litigation. What should the BVI court allow its liquidator to do in a foreign court? That's that's putting it the wrong way in relation to this case. The right way to look at it is, what should the defendants in the position of my clients have to endure in terms of litigation in a foreign court? My Lords, there's nothing inconsistent, I say, in the construction which I'm advancing of Section 249, which is inconsistent with the approach taken by the BVI courts to assistance in cross-border insolvency cases. My Lords, the common law of the BVI, your Lordship should assume, adopts modified universalism as the approach to cross-border insolvency. The best definition of cross-border, of modified universalism is now to be found, I submit, in Lord Sumption's judgment in the Singularis case. If I could just ask you to look briefly at it, though I don't want to get too drawn into modified universalism, because I respectfully submit this case, as my Lord Reid said at the outset, is a short point of construction on Section 249 of the Act. But if you go to A3114, 4302 in the bundle, sorry, it's 4284 is where it starts. And if one just looks at paragraph 19 at page 4302, what Lord Sumption has done in his judgment up to paragraph 19 is he's gone through the cases, and he's referred to the debate that went on about Cambridge Gas on the one hand and Rubin on the other. He effectively adopts the approach taken in Rubin, which is to say there are no special rules of private international law, and he's pushing back in effect on what Lord Hoffman had said in Cambridge Gas. But then in paragraph 19...
I beg your pardon. Please give me the page again.
Sorry, 4302.
Thank you.
And there, if I just invite your Lordships to read paragraph 19 of Lord Sumption's judgment, including the quote from Lord Collins and Rubin. My Lords, stop me if I'm going, if I'm...
Yes.
What I submit the common law principle is that modified universalism means that the courts of the common law world will accord maximum assistance to foreign courts in giving effect to foreign insolvencies on the basis there should, as far as possible, be one law applying to the assets of the debtor throughout the world. But that is modified by the recognition of the fact that if the insolvency law of the debtor can reach anywhere in the world and override local law, that can unduly interfere with reasonable commercial certainty. There needs to be some territoriality to the extent to which the law of the main insolvency proceedings will apply. Examples of where the English courts have said yes to modified universalism is investing of English assets in a foreign office holder, and that's the Transvaal case that Lord Supson referred to. Examples of where they've said no are, for example, remitting assets to a foreign jurisdiction which would not apply the assets pari passu, and they've said no to recognising foreign insolvency judgments where the normal principles of PIL have not been complied with, private international law, and that's Rubin. My Lord, these principles demonstrate that universalism is not untrammelled. That means that the BVI courts, when they're dealing with incoming, are not required to apply the law, all the law of the main insolvency proceedings in respect of a debtor. Looking at the position from the other perspective, it would not be surprising if BVI legislation had intended that in relation to the insolvency of BVI debtors, and in particular the avoidance provisions, it was only the BVI courts and not the foreign courts that could apply Section 249. Because what modified universalism is dealing with is we want one court to broadly try and make the same regime apply everywhere, but we need some limits to that, because you can't just have a law coming in and disturbing settled relationships. The way that that is dealt with is by, where there's no international provision dealing with it, by the courts looking at a case-by-case basis and deciding what the right answer is. In relation to avoidance, it's plain that what the BVI had in mind was that only the BVI courts could apply their avoidance provisions.
But you couldn't have had any objection, could you, if the liquidator had been authorised to start liquidation proceedings in another jurisdiction in order to get in the assets?
Correct. If he'd done an ancillary application, and the reason why there is a difference between the ancillary application is because what you're dealing with there is the territorial jurisdiction of the country in which the ancillary application is brought. Because there is an assumption that if I am in the United States of America and liquidation proceedings are brought and I'm within their territorial jurisdiction, then I cannot complain if, in relation to assets I've got within it, they are then subject to a US winding up. If you look at if you go to the BVI insolvency law, which is bundle A5, this is looking at it from the BVI's position. They can do a ancillary liquidation. Look at A51284703. I don't need to look at the detail of it, but look at 163. That allows them to appoint a liquidator in respect of a foreign company, which is like English law. If you then go to section 2444...
But that's a BVI liquidator of an overseas company.
Yeah, that's correct. So
I wasn't thinking of that. I was thinking of where the liquidator is authorised to go and start liquidation proceedings, let's say, in the UK, in England and Wales.
He would be, if the BVI liquidator was authorised to be appointed a liquidator, it would be pursuant to the English power to have an ancillary liquidation. It's the same.
So the creditors buy into a liquidation in which that can occur.
They do, that's correct. But that is subject to all the protections that creditors and debtors have according to the law of the liquidation of the territory in which they're in. Just to complete that point, if you go to section 2444, which is A51284734, if you go back to 4733, this is, as it were, the beginning of Part 8 of the Insolvency Act, in which section 245, 246 and 249 are to be found. And it's saying to whom it applies. And if you go to sub 4 on 4734, all of the avoidance provision, if you look at 4B, a company includes a foreign company. So they're saying the foreign liquidation provisions, the BVI avoidance provisions, where there is an ancillary liquidation under section 163, will include being able to apply the BVI avoidance provisions in respect of a foreign company. Mm-hmm. They're not envisaging that the US provisions would apply if it was the other way around. They are envisaging it would be the BVI provisions that apply. If you go to the UNCITRAL model law, if you go to A51284817 in the same statute, (4361), this is the UNCITRAL model law. These provisions have not been brought into force in the BVI and were not relevant to any of these the particular proceedings we deal with here. If these reflect the UNCITRAL model law, if you go to 454,
Section 454.
Section 454, which is page 4823, this sets out the relief that, I'll come to it probably after lunch, but there's a provision in, there's something called Article 21 in the UNCITRAL model law, and this sets out most of the relief in that, but not all of it. It doesn't contain a general catch-all. And then in relation to avoidance provisions, look at 4561, subject to subsection 2, upon recognition of a foreign proceeding, the foreign representative shall have power to apply to the court for an order under section 249 or 405, don't worry about that, as the case may be. So what they envisaged under the model law was that you didn't apply foreign avoidance law, you applied the avoidance law of the country where you were seeking to get the assets, which is reflective of the proposition that they were worried when drawing up the foreign law about, as it's swooping in from a foreign country and applying a different law.
You said that was 461?
No, 4561. I apologise.
No, it's clever.
And if you go to 562/1352, which is the UNCITRAL materials, you go to 562/1292, that's the beginning of it.
What's the page number?
1292. It's in bundle. It's not bundle. It's the main bundle, not the bundle of authorities.
Yeah. Oh yes, tab 62 and bundle
62.
5.
62. Yeah.
Yep.
Page 1292. This is the model law, and just quickly, go to 1305. Article 21 of the model law reflects section 454 of the Insolvency Act 2003. But it does not include little g in the model law, which is, quote, granting any additional relief that may be available to insert the title of a person or body administering blah, 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 under the laws of this state. And take it from me, this state means the incoming, the assisting state, not the foreign state. And then 456 of the Insolvency Act 2003 and the BVI reflects Article 23. If you then go to 1309, you'll see something called Guide to Enactment of the UNCITRAL Model Law on Cross-Border Insolvency. If you go to para 154...
Yeah, I've got a wrong page number.
Sorry, 1309, you see at the bottom of 1309 the words Part 2.
Oh, yes, yeah.
So the way this functions is Part 1 is the actual model law itself, Part 2 is the guide, and in all of the enactments of the model law, including in the UK, judges are entitled to look at the guide as to what it may mean, basically, and they're all in one document. And then if you go to 154,
1352.
1352, thank you. Yep. And I simply refer to the types of relief listed in Article 21, paragraph 1, which is what are typical or most frequent in insolvency proceedings. However, the list is not exhaustive. The court is not restricted unnecessarily in its ability to grant any type of relief that is available under the law of the enacting state, and that means the BVI in this case, and needed in the circumstances of the case. And then in relation to the avoidance provision, if you go to 165, go to 1354. You see Article 23 and then 165, and I invite you to read that. It's drawing a distinction in 165 between, as it were, the sorts of case that my Lord Reid referred me to, the individual, the old-fashioned one, and the newfangled one, and these only apply to the newfangled ones. And then and 166. I submit that what that's saying is that the model law is giving you the right to bring proceedings under the law of the enacting state. It's not solving any problems about private international law, but it is most certainly not envisaging that you can bring claims under the US law's provision in this case. Lord, I don't know if that's a convenient moment.
Certainly.
Very much ago.
The court will adjourn.